Judge Mogen, before
I am going to tell you, Ms. Erdman, I do require that the document be filed by the defendant personally and then filed with the court. This one time I will print it and I will have Mr. You have it? Okay.
The DGOCs, I don't know if that's.
I will print it.
Yeah, I had him.
This is one of those courtroom moments that reminds us justice isn't always about punishment. Sometimes it's about redemption. Two parents stand before Judge Mogen, facing serious felony and child neglect charges tied to drug use and the safety of their children. The stakes couldn't be higher: felony convictions, loss of parental rights, and a future permanently marked by addiction. But what makes this hearing extraordinary isn't just the charges. It's what the judge already suspects. She believes these parents were still using during their first child protection case, and today may be the first time they admit it out loud. This case isn't just about meth, neglect, or criminal penalties. It's about whether people who once beat the system can truly change. The prosecution wants structure. The defense wants rehabilitation. And the judge? She wants proof that these parents can stay sober long enough to raise the very children they endangered. As we step into this joint plea hearing, watch closely, because the legal agreement being discussed could either save this family or collapse if they fail even once. The real question is, when addiction and parenthood collide, how far should the court go to give someone a second chance?
That and then sign it. First review it to make sure it is that document and then you can sign it. Yes, Ms. Erdman?
I was just going to explain. I had reviewed it. I signed off on it, and then I sent it over to.
So it has your name right there. So
And the document that I handed Judge Michelle was the DJOC for this as well as the other case.
Otherwise, essentially, we're doing the same thing twice.
I can. I just what I try to do is I try to get all of the information in before we start, if we can,
Yes.
and then
So you
can
tell me when you're ready,
Okay.
and then we'll be good to go, because I think that's just for efficiency of the court.
All right. Yes, I will.
I like your hair, Miss Ford.
Thank you.
New color, new you.
Yeah, feeling it.
Okay, so while I have counsel here and
If you want to bring that up.
the defendants, I'm going to call these cases together. They are, I believe they're essential. Well, unless you're not pleading to the same thing.
No, it should be the same.
Okay, so it's the same thing. So I'm going to call the cases together and I'll go everything over, go over everything with both of you at the same time. If you need me to repeat something, let me know, but for ease and efficiency, that's what we're going to do. And we'll try and go slow because it's harder for the clerk to be able to do two dual cases at once. Okay? Just let me know when you're ready.
Yes, we should be.
We will go on the record in the matters 25 CF 67, State of Wisconsin versus Cheyenne Ford, 25 CF 68, 25 TR 37, 25 TR 237, 238, 239, and 240. State of Wisconsin versus Christopher Martin. This is a joint plea hearing as both parties are in a significant relationship together. They have children together. It's the same charges for the most part, but they are pleading to the same charges. And for ease of court and efficiency purposes, we are going to do a joint plea agreement. Off the record, the court informed the parties that this is what is going to occur, to listen very carefully because this is going to be for both of them. And if they have questions, they need to ask the court to briefly stop so that we can get it answered to make sure everything is done appropriately and correctly. All right. So appearing, we do have the state appearing in person through District Attorney Kevin Schmidt. We have Glenn Keene, Defense Counsel for Cheyenne Ford. Cheyenne Ford is here. We have Christopher Martin. We have appearing by video conferencing, Attorney Michelle Erdman, who represents Christopher Martin. For set for plea and sentencing, the parties have reached an agreement, and it is essentially identical, or is an identical agreement. I have deferred judgments of convictions and the plea questionnaires, or do I have two plea questionnaires Mr. Keen, for the record, can you recite the agreement?
Yes, Your Honor. In 25 CF 67, and then in 25, in their case, it calls for Ms. Ford to plead guilty to counts 3 through 5, with counts 1 and 2 dismissed and read in for sentencing. The joint recommendation is below. Count 3, the felony, recommending a 2-year deferred judgment of conviction for 2 years with an administrative fee of $150. Conditions for successful completion of the DJOC is that parents must comply with the CHIPS case and achieve reunification, early termination of the DJOC, and dismissal of the felony if the CHIPS dispositional order is fulfilled and terminated prior to the 2-year mark. Regarding count 4, the neglecting a child misdemeanor specified harm did not occur. It calls for imposition of DNA costs, joint recommendation for 2 years of probation with conditions of an alcohol or drug assessment and follow through compliance with the CHIPS order. And it would also allow for early discharge from probation should the CHIPS order successfully conclude. Per Wisconsin statute 973.093D2, the period of probation must be at least 1 year and all financial obligations must be paid. Count 5, the possession of drug paraphernalia is for DNA and costs only.
All right, so count 5 is for costs only. Okay, all right. So 5 costs only. All right, and Ms. Erdman, is that the exact same agreement that Mr. Martin has reached with the state?
It is
For clarification,
Clarification.
yes. All right, thank you. Okay, now, Ms. Ford and Mr. Martin, I'm going to go slow so that you both can understand. And then I'm going to have one of you say the answer first, and always, Ms. Ford, you're going to respond first, and then Mr. Martin for ease of the court reporter, okay? All right, so I have in front of me a plea questionnaire waiver of rights form. Did your attorney go over this form with you thoroughly?
Yes.
Yes.
Did your attorney read this to you essentially word for word?
Yes.
Yes.
Do you understand everything completely?
Yes.
Yes.
If you didn't understand something, did you ask your attorneys to explain it?
Yes.
Yes.
And they did so.
Yes.
Yes.
Did you sign that plea questionnaire?
Yes.
Yes.
You are pleading guilty to 3 counts. Count 3, which is a felony, count 4, which is a misdemeanor, and count 5, which is a misdemeanor, correct?
Yes.
Yes.
As to whether or not you have a high school diploma, and if you've had any medication or alcohol or any mental illnesses or disorders, what's checked on the form is accurate, correct?
Yes.
Yes.
Because you're charged with crimes, you're entitled to constitutional rights. Each of those rights is listed on the first page of that form. Did your attorney thoroughly go over those rights with you?
Yes.
Yes.
You understand them completely.
Yes.
Yes.
If you did not understand your rights, you asked your attorney to explain them.
Yes.
Yes.
Do I need to explain them to you any further?
No.
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Yes.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes.
Yes.
Do you understand you're pleading guilty to a felony if the court either does not enter the deferred judgment of conviction, or if at a time the judgment of conviction gets revoked because of non-compliance? Do you understand that at that time the felony will be entered and you will no longer be able to use or possess a firearm for life?
Yes.
Yes.
You wouldn't be able to vote in any election until your civil rights are restored.
Yes.
Yes.
Here in this case, as to count 1, possession of methamphetamine, the state would have to prove on or around April 28th, 2025, that you possessed a substance and the substance was methamphetamine. Point, please. As to count 3, neglecting a child, specified harm did not occur and the child was under the age of 6. Do you understand the state would have to prove on or around April 28th, 2025, that being a person who's responsible for the welfare of a child, KM, date of birth, July 20th, 2022, through your action and failure to take action for reasons other than poverty, you negligently failed to provide so as to seriously endanger the physical, mental, or emotional health of the child, and the natural and probable consequences of this violation would be harm, although harm did not occur. Do you understand what the state would have to prove?
Yes. Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years or both?
Yes. Yes.
Do you understand that as to count 4, neglecting a child, specified harm did not occur, the state would have to prove the same date, the same time, the same place, that being a person responsible for the welfare of a child, EM, date of birth, October 6th, 2017, through your action and failure to take action for reasons other than poverty, you negligently failed to provide so as to seriously endanger the physical, mental, or emotional health of the child, and the natural and probable consequences would be harm, although harm did not occur. Do you understand that this is a misdemeanor count?
Yes. Yes.
And you understand what the state would have to prove?
Yes. Yes.
You understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both.
Yes. Yes.
As to count 5, possession of drug paraphernalia, do you understand the state would have to prove the same date, time, and place you knowingly possessed with the primary intent to use pipes, plastic gem baggies, burnt tinfoil, and cut straws to inhale, ingest, and store a controlled substance? Do you understand what the state would have to prove?
Yes. Yes.
Do you understand that upon conviction, you could face a fine of up to $500 or imprisonment of up to 30 days or both?
Yes. Yes.
Do you understand that there is an agreement between all of the parties here, the same agreement, and there is a recommendation for the court to adopt a deferred judgment of conviction for the felony, place you on probation for count 4, a misdemeanor, as well as count 5 for costs only? Do you understand I'm not bound to follow that? I don't have to follow it. Do you understand that?
Yes. Yes.
So if I thought, based upon the facts of this case and other facts and evidence and testimony about you, that a different sentence should be decided, including jail, do you understand that I can do that?
Yes. Yes.
Do you still wish to proceed and enter guilty pleas?
Yes. Yes.
Did your attorney go over the criminal complaint, and that is the facts alleged in that complaint with you?
Yes. Yes.
And for the most part, are those facts accurate?
Yes. Yes.
Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Ms. Erdman, may I do so as well?
Yes.
All right. So has anyone made any threats or any promises to you for you to plead guilty today?
No. No.
You're doing so freely and intelligently and voluntarily.
Yes. Yes.
Has your attorney represented you competently?
Yes. Yes.
Have they answered all of your questions?
Yes. Yes.
Have they looked at this matter thoroughly?
Yes. Yes.
Are you satisfied with their services?
Yes. Yes.
Any questions for the court or for your attorney before I proceed?
No. No.
And Mr. Martin, directed to you, your attorney's appearing by video. You had indicated you were okay with her appearing by video, knowing that you have a right to have her be in person. Are you still okay with that,
Yes.
even with the sentencing?
Yes.
All right. So based upon that, the court will ask Ms. Ford first as to count 3, neglecting a child, no harm, and child was under the age of 6, an I felony. How do you wish to plead?
Guilty.
Mr. Martin?
Guilty.
As to count 3, neglecting a child, specified harm did not occur, a class A misdemeanor. How do you wish to plead?
Guilty.
Guilty.
As to count 5, possession of drug paraphernalia, a misdemeanor. How do you wish to plead?
Guilty.
Guilty.
The court will find your pleas of guilt for both parties is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find both of you guilty of count 3, count 4, and count 5. As to counts 4 and 5, a judgment of conviction will be entered today. The court will consider whether to adopt the deferred judgment of conviction for the felony. Mr. Schmidt, argument.
I think the court can probably have.
What we're seeing here is a highly strategic plea agreement. And honestly, it's more sophisticated than most viewers might realize. The prosecution isn't just punishing past behavior. They're engineering future accountability. By tying the criminal case outcome directly to the CHIPS child protection case, the state has essentially created a legal incentive loop. If these parents stay sober and reunify successfully with their children, the felony conviction disappears. If they fail, it comes crashing down. This is sometimes called a carrot and stick sentencing design, and the prosecutor openly admits that's exactly what he's doing. The deferred judgment hangs like a sword over their heads, while early dismissal offers a reward for compliance. It's also notable that the paraphernalia charge exists mainly to justify probation supervision. That's a rare moment of prosecutorial transparency in open court. So here's the big question for you watching. Is this the right balance? Should criminal courts tie outcomes to family court progress like this? Or does that put too much pressure on parents already battling addiction?
Infer what I'm trying to do with the structure of how I did this. These are the only parents that EM and KM are ever going to have. We have to work with them to make sure that both Cheyenne and Christopher are going to be able to take care of them, that they're going to be safe, and even more than that, that they'll thrive in the future, that they'll have a happy childhood and grow into happy adults. We had a CHIPS case not that long ago with these same children, with these same parents, with really the same sort of allegations. They crushed it. They got sober. They demonstrated they were capable parents. We know they're capable of that. Unfortunately, the sobriety did not hold after the completion of that CHIPS case, and the second case started. That's why we're doing more structure this time. Nobody doubts that they're going to be able to demonstrate sobriety again, that they're going to demonstrate they can take care of their children again. That's going to happen. I want to make sure that we have these criminal cases here as both a sword. There's a tremendous amount hanging over their head with these two cases that are going to have probation or the DJOC. The paraphernalia is really only there to allow me to do 2 years probation on the misdemeanor child neglect. That's why it's there. But also a carrot, because we've tied the resolution to the probation and the DJOC to the disposition of the CHIPS case. With the DJOC having the clause, it can end early if the dispositional order is completed, and the same for the probation. The reason for that is if we should tie the conclusion of, state of Wisconsin versus Cheyenne Ford and Christopher Martin to anything, it should be tied to, in the interests of EM and KM, it should be tied to what's best for those children. And by tying it to how that CHIPS case, where we get to have that as the primary goal, in a way we can't necessarily in this criminal case, because that's not McCleary-Gallion. I think that's the best way to achieve the best results for the community, for the victims of this case, the children, and for the rehabilitation of the parents. I'd ask the court to follow this. I don't normally push like a hyper-specific structure like this, but in this case, I really want to do that because I want this there. I want the possibility of DOC resources to complement CHIPS resources if we ever need it. We really see that working out really great when we do treatment court, where we have those DOC resources complementing treatment court resources. I like the idea of trying that here with county DHS resources, with state DOC resources. I think that relationship, that combination of services can only serve to the benefit of the children, and that should really be the goal here. Thank you.
Thank you, Mr. Schmidt. Mr. Keen?
Yes, Your Honor. When looking at the sentencing factors, this case, as D.A. Schmidt pointed out, does focus on rehabilitation of Ms. Ford by, encouraging her to comply with the CHIPS conditions, which are, and having an alcohol or drug assessment. It also focuses on protection of the community and specifically the children by having that sword hang over their heads. The only thing I would like to mention is that it also does have some punishment element because until today, Ms. Ford had only had traffic offenses in her life. Today, she has a misdemeanor conviction if the court abides by the DJOC, and obviously felony if the court decides not to. It also has an occupational bar because once you have a misdemeanor conviction for neglect of a child, that bars you from working in the child care industry, opening your own daycare, et cetera, and that's a permanent bar. So while this case is not focused on those items, I just wanted to note that it does have, some punishment aspects, so that factor is met as well. Although fortunately, it is focused more on rehabilitation and protection of the community.
Thank you. Ms. Erdman? Thank you. Ms. Ford and Mr. Martin, I'm going to give you both an opportunity to make statements, to tell the court anything you want me to know. Candidly, I know a lot because I've been on all of the cases. But tell me again, because whatever you want me to know, I want to know before making any type of sentencing decision. Ms. Ford?
I wasn't really prepared to go first.
Mr. Martin?
There's just been one thing that we've kind of wanted everybody to know. Is we've informed Katie about this from the beginning. Our first case around, I wish we could say that we were sober, but the lack of effort from that social worker that we had, and it being the addicts that we were, it gave us the opportunity to still use that entire time. We could time it up. We were timing things up perfectly. Being an addict, we were very opportunistic, I guess. So like I said, I wish we could say we were sober that whole time, but we weren't. We were not. This is the longest that we've been sober. This is the longest I've been sober in over a decade. And now that we have this support system, now that we took in, that experience that we did, that we went through for just that month. I mean, it's changed everything. I went there with the mindset of like, all right, I'm going to go do this for the court, make it look good on paper. First week went by and it's one day something just clicked, and it's something that I've embraced, every day is a struggle still, but just being able to fall back on those foundations that we learned, the support systems that we've gained, it's changed everything, so.
This is the moment the entire courtroom dynamic shifts, and you can feel it. Up until now, this hearing has been procedural, charges, statutes, agreements. But what Ms. Ford just admitted is legally and emotionally explosive. She confessed that during their previous child protection case, when authorities believed they were sober, they were actually still using and timing drug use to avoid detection. That admission does two things instantly. First, it validates the judge's earlier suspicions, something she'll acknowledge shortly. Second, it reframes today's sobriety claims. Because now the court isn't evaluating whether they used in the past. That's proven. The question becomes whether this time is genuinely different. And notice something subtle. The judge doesn't punish the admission. She praises it. That's not softness. It's a deliberate judicial tactic. Honesty is the first measurable indicator of recovery compliance. Courts dealing with addiction often treat truthful disclosure as evidence of rehabilitation progress. So what do you think? Does admitting past deception make them more trustworthy now or less?
That is just one thing I wanted to say is that the first time around, I wish we could say we were sober, but we were not.
I applaud your honesty. I truly do. And I'm going to say that it's not just you who has done that in the past. People who have substance abuse disorders do that. They know when to time. Not all of them are as honest and open as you. So I applaud you for that. How many days have you been sober?
I think I just broke 130 days.
That's amazing. Good job. I'm very proud of you.
Thank you.
Ms. Ford?
So, right around the same time with his sobriety, I can't tell you exactly the date. I mean, the date after the arrest. But I will say, and this is something that I had told to our caseworker, that sadly, this is something that I needed. I needed this to happen, as terrible as it was. Needed it to happen to get the help that I needed and to be able to raise the family that I know I can. And like he had mentioned, it, something clicked, and it's like, why did I even do that? Why, what was I thinking? Because honestly, this feels great. This is amazing. And to see my children now thriving, it's great. And, not to have to worry about this or that, or, going to figure out how I'm going to get here or there. I don't have that worry anymore, and I can just focus on my children 100%. And I haven't been able to do that, and it's great.
Man, I'm just so proud of both of you. I truly am. I truly am so proud of both of you. How many days have you been sober?
I mean, since the arrest, so after April
Since
29th.
Same sobriety date.
Yeah.
April 28th.
Yeah.
I am so proud of both of you. I truly am. I'm going to tell you, this job gets daunting at times, and it causes a lot of lows a lot of times, because I get invested in the people that are in front of me. And so it really brings me down. And I don't want to say it makes me a cynic or somebody who doesn't believe that change can happen. I do truly. But when I get invested and I see people, and then I see the dishonesty, like you said the first time around, you had it timed, you had it good. You knew how to, quote, beat the system and still be able to use, because that is what was driving you. Meth was controlling both of you. And you took control. You controlled those demons. And you are at a point right now where you have the ability to make the greatest life possible, to have a great, you're not married, but to have a great relationship together, and to have a great family together, and to raise two beautiful children. I got the pleasure to meet them that one day. They are beautiful children. You should be so proud. And again, so proud of your daughter. I'm extremely proud of your daughter. She did a good thing. And you two are here, and the demons were controlling you. Meth was controlling you, but you are now taking charge, and you're going to school, and you guys are starting this business, and you're doing all of the things to improve your life and your family. And it can only get better. It can only get better. I agree with you, Mr. Martin. I don't know personally how it is and that struggle, but I hear it every day, every single day. I hear it and I know it about the struggle of sobriety is an hour by hour until you can go a day by day, and then you build and you can go a week by week. You are constantly working on yourself and constantly dealing with the triggers and all of the things that are trying to draw you back to methamphetamine. You are conquering it. You are knocking it out of the park. I have never been so proud of two people in front of me. When I saw you the first time, I'm not gonna lie. I didn't know for sure, but I had very strong suspicion that you were still using. I see people every single day. I can tell when people are sitting there high or they are still under the influence. But my job is not to call them out every single time or to send them to jail or to do those kinds of things unless it's a time to do so. And I have done so. But the fact that you are admitting that, and you have admitted that, that takes power. That takes strength to be able to do that. So keep moving forward.
Judge Morgan's response here is extraordinary in tone, but very deliberate in law. She openly states she suspected they were still using before, something judges almost never say on record unless they're about to pivot toward leniency. Why? Because she's establishing credibility for her sentencing decision. She's signaling, I wasn't fooled. I'm choosing to give you another chance anyway. She also reframes the case from punishment to prevention. Notice how she emphasizes that the real victims were the children and that harm could have occurred. That matters legally. Child neglect charges often hinge on risk, not injury. The fact that no child was physically harmed allowed this plea structure to exist at all. But here's the key takeaway. The judge is making their future identity part of the sentence. She tells them they can now help others with addiction. That's not motivational speaking. It's rehabilitation theory in practice. Courts increasingly view recovery identity, seeing oneself as sober and responsible, as a protective factor against relapse. So the real sentence here isn't prison. It's expectation, and failing that expectation would reactivate a felony conviction instantly.
These charges, are serious because they do involve your two children, and you did put them in harm's way. Thank the Lord, nothing happened, and that your children didn't accidentally ingest the substances or anything of that nature. You have a great history in front of you. Ms. Ford, unfortunately now you have a criminal record, but that doesn't mean that it needs to define you. You can move forward from that. You can have your story. Now you both can go and share your life and your story and the lessons you learned to others. You can help others in their sobriety. You still have a long time to be able to totally get control over yours. You do have great control. But again, as you said, it's a day by day kind of thing. But you can help the community. And that's amazing. And that is great. With this agreement, I don't think that the community is going to be at risk. I think it's actually going to do good. Because then you both get to avoid having a felony conviction. And then you can continue on with your success and your great stories and the things you want to do. So with regards to the matter, I will adopt the deferred judgment of conviction. Again, you understand each of you must pay $150 within 60 days. Do it, because that's the number one reason I see the state asking to revoke these. So do that. And make sure you comply with all of the other conditions. You must comply with CHIPS, but I'll go into that. All the things that are in the DJOC are going to be in the probation, so I'll just wait for that. With regards to count 3 or count 4, that I'm going to sentence you to 2 years of probation. You must follow the CHIPS order, regular drug testing, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol. Any other condition that your agent deems appropriate or that your caseworker deems appropriate. $443 in fines and fees. As to count 5, I'm only going to assess $200 as the DNA surcharge, as that is a mandated charge I must assess. I'm going to dismiss, or I'm going to waive the rest of the court costs and fees. You already have enough things to worry about than all of the money that you're going to need to pay. You're each going to have your own separate accounts, but you can pay it all together in one, maybe 2 checks. I don't know how you're going to have to pay it with the clerk's office. But with regards to that, I'm going to assess $50 a month per person. That's a low enough amount that you can still support yourself and your children, work on your sobriety, and move forward. If you fail to pay, not only will the court enter a civil judgment against you, the court will issue a warrant. You could sit up to 6 months in jail. It's very important you at least make your monthly payment until it's paid off in full. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need your DNA. So both of you will need to go to the Sheriff's Department and see if they need that, provided if they do. And you have the ability to request it be expunged through a written letter to the Department of Justice, not to the court, but to the Department of Justice. I need to verify your address is still on West Hurdle Drive.
No.
Oh, well, let me see if I have yours correctly. What is your address then?
7111 Loon Creek Circle, Danbury.
Okay, and I have a telephone number ending in 9109 for you, Mr. Martin.
Nope.
Well, then I do have another one. It ends in 1410.
Nope.
Okay, may I get another one?
715-214-8802.
8802. May we send you text messages if we need to?
Yeah.
Ms. Ford, I will update your address as well, and telephone number ending in 2362.
No, just use the one that you took for him because
Okay.
I don't know if I'm gonna stay with my phone provider.
All right, that sounds good. So 715-214-8802. I think that covers everything. What am I missing, Mr. Schmidt?
Nothing from me.
Only thing I'd ask, Your Honor, is for,
Oh, I forgot to state on the record. Thank you. Sorry to interrupt, Mr. Keen, that with regards to the chips as well as with probation, that if you successfully complete all of the conditions, you stay sober, you do all that you need to do, you pay off all of the fines and fees in full, the court I will not object and I will sign off on early discharge of probation and early discharge of the deferred judgment of conviction, all right? But as I don't know if that's exactly what Mr. Keen said, but the statute, and it's up to the Department of Corrections if they are going to allow you to discharge early. I just sign off on it. So you must meet all of those conditions, et cetera. They cannot have early discharge until at least half of the probation has been set. So you must have at least 1 year of probation and do all of these things, okay? Sorry, Mr. Keen.
yes, Your Honor, for Ms. Ford's case, she mentioned that she's not presently employed. And I was going to ask that $150 of the 500 cash bond posted, if that could be placed with to cover the DGOC administrative fee.
I forgot that there's cash. Is there 500 each?
Yeah.
So you each posted 500?
Yeah.
All right. What I'm going to do is I will direct the clerk to send $150 per case over to the district attorney's office to cover that fee. And then you will have $350 more that has been paid off. And so just continue your $50 a month payment, okay?
Okay.
Anything else, Mr.?
This hearing is a powerful example of how modern courts handle addiction-driven family crime. Both parents pled guilty to felony and misdemeanor child neglect charges tied to meth use around their children. Instead of entering immediate felony convictions, Judge Morgan adopted a deferred judgment structure, meaning the felony disappears if they remain sober, comply with probation, complete child protection requirements, and pay all financial obligations. If they fail, the conviction returns with full lifelong consequences. The court balanced 3 goals: protecting the children, rehabilitating the parents, and safeguarding the community. And in a rare moment, the judge openly acknowledged she once suspected they were still using, yet chose to believe their recovery now. Their future literally determines their criminal record. Cases like this raise difficult questions. How many chances should addicted parents receive? And when does accountability outweigh rehabilitation? If you found this case as shocking and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.